State of Nevada versus TikTok, case 886127, pages 5 through 7.
Thank you, Your Honor.
Thank you, and thank you for doing pro bono. Okay, and let counsels for plaintiff first make their appearances and then counsels for defense. And if you all, anyone remotely, just let us know, or if they're going to introduce themselves, just let us know. Go ahead, please.
Thank you, Your Honor. On behalf of the state of Nevada, William Sykes from Claggett and Sykes Law Firm. We also have Richard Hyde from my office here in person. We have Bill Carlson from the Nashwaati Law Group. We also have Chris Terzo from Morris Sullivan Wonderful Terzo. On the line, I believe we have Matt Bush from Nashwaati Law Group. We have Christian Barton from Morris Sullivan. We have Dory Tesser from Nashwaati Law Group. There might be a couple of other individuals on there, Your Honor, that might be with the plaintiff's counsel, but those are the ones I recognize, and I think they may have appeared in the chat as well.
Okay, thank you. Counsel for defense side, go ahead, please.
Good morning, Your Honor. My job isn't as hard as Mr. Sykes. Colby Williams on behalf of the defendants, along with Steve Brody from Albany and Myers and my partner, Phil Irwin.
Okay, anybody remotely?
Observing, but not appearing.
Okay, no worries. Just want to make sure someone wanted to put their name on the record. They're more than
Understood.
glad to do so. Some of those new,
Of course.
as you all know, newer bar people. Okay, so feel free to sit down, stand up, whatever's comfortable. I was going to address hopefully the quickest and easy thing is, well, it's not set until September 16th, 2025, a motion to associate counsel filed by the plaintiff state of Nevada.
No.
The court could have a chance to review it. You all usually have been very collegial and have asked the court to advance them under 2.23 and grant them under 2.20, as long as they meet the standards of Supreme Court Rule 42. So for defense, do you have a position?
I agree with that approach, Your Honor. No opposition.
I guess I should have asked in reverse order. Counsel for plaintiff, was that a request?
Yes, sir.
Okay, so based on the request of plaintiff's counsel that the court advance the motion to associate counsel currently set on 9/16/2025 to today, there being no opposition by counsels for defense, that is advanced to today under EDCR 2.23. Since the court had had a full opportunity to fully review it under Supreme Court Rule 42, it meets those appropriate standards. Then the court's also going to grant it as unopposed, since I heard defense counsel has no opposition. That grant is unopposed and also on the merits. So that means we can vacate the 9/16 date, but means it starts your EDCR 7.21 to please get us the appropriate order to associate counsel. And then please remember, and I say this, I know you always, all the counsel here in front of me always do it, but I say it because many people don't. As a friendly reminder, you include the sentence, right, that they will comply with all the Supreme Court 42 and that local counsel will comply with his local counsel obligations. Okay.
Thank you, Your Honor.
Appreciate it. That was my easy part, right? Okay, now let's get to what you're really here for. Defendant's motion for a stay of discovery, document 175. Plaintiff state of Nevada's opposition thereto, document 178. Defendant's reply, document 181. And then we also are going to have your rule 16, but we'll deal with that in a few moments because obviously it'll be impacted by the first. So counsel, remember you all did not ask for a special setting, and you can appreciate we've got lots of people, so that means I'm going to hold you to 5 to 7 minutes-ish with not including questions by the court. Go ahead, counsel.
Perfect. Thank you, Your Honor. Colby Williams on behalf of the defendants. I should have no problem meeting that time limit. I know the court's familiar with the Rule 8 factors that govern stays. I know the parties have briefed them thoroughly in their papers, and so I'm not going to repeat any of that. I want to focus on one thing that I think is significant, Your Honor, and that is the fact that the Nevada Supreme Court, less than a month ago, has granted a motion to stay discovery in the Snap case.
Well, I thought you were going to mention something else, but go ahead. But that's not on until this department until Thursday.
Right. So we attached it as Exhibit 2 to our reply as the order granting the stay in the Snap case. Now, Your Honor, I don't need to tell you, you're familiar that the
I'm not
state,
Department 25.
you are not, but the state has filed multiple actions against various online platforms. Snap is in front of Judge Delaney. The Meta cases in this case are in front of you. But Your Honor, I don't think anyone would dispute that these cases are very, very similar. The claims against Snap are the same against the TikTok defendants. The defenses that Snap has raised are the same that the TikTok defendants have raised. Most apropos here, lack of jurisdiction, protection under the First Amendment, and immunity under Section 230 of the CDA. And the Snap case and this case are in the very same procedural positions. Motions to dismiss were filed, they were denied, Writ petitions were filed, answers to the complaint were filed. The parties had an early case conference and joint case conference reports were filed. The difference, Your Honor, is that our writ proceeding is further along than SNAP's. We have fully briefed it. We argued it to the en banc court on June the 4th. We're awaiting a decision. Now, SNAP filed a motion to stay discovery in the front of the district court, which was denied. It then filed that motion in front of the Supreme Court. And the state opposed that motion, Your Honor, on June 11th, 1 week after we presented our oral arguments. And the reason I'm spending time talking about this is because I think the state's opposition there is incredibly relevant here. Because in 22 pages, and we've attached this as Exhibit 3 to our reply, in the 22-page opposition they filed before the Supreme Court, they made these same arguments as to why a stay shouldn't be granted there that they are making here. What are those arguments? That SNAP waited too long because it answered the complaint. It participated in a 16.1 case conference, and it filed a joint case conference report. Same argument you see throughout their briefs here. On the first Rule 8 factor, SNAP's writ, the object of SNAP's writ petition won't be defeated because jurisdictional defenses are preserved until trial. Exact same argument they make here. Factors 2 and 3, which balance the parties' respective harms. They say the state is harmed far greater because they are seeking to vindicate the interests of Nevada's young people who have allegedly been harmed by these online platforms, whereas all SNAP was complaining about was the burden of litigation costs. Same argument they make here. And on the final factor, they say SNAP could never show a likelihood of succeeding on the merits because the district court denied its motion to dismiss. The same argument they make here, Your Honor. Now, respectfully, the Nevada Supreme Court wasn't impressed. They didn't accept any of those arguments. They granted SNAP's motion to stay discovery, and discovery has stayed for the duration of that writ proceeding. Now, I expect the state will stand up and is going to make these same arguments to you all over again, and I'm fully prepared to address them, Your Honor, but I don't think I need to. I think it's more effective and it's far more succinct to say these exact same arguments you're going to hear, the Supreme Court heard and rejected. We think you should do the same.
Do you have a question?
Yes.
No surprise, right? Okay. Going to, well, you all agree the Hansen factors is what the court evaluates the case on, right?
Mhm.
Okay. So whether or not a stay will cause harm to the state, right? And they raise a couple of different issues, one of which is like changing things that can happen, destruction of evidence, right? Because of the timing of the potential stay, if you look historically on how long writ petitions have taken with the Supreme Court, that's not a negative comment. That's just a realistically, you all do the stats, you do the time periods, nothing surprising, okay, there. So how does the court address that factor?
Sure. Well, starting with Hansen and with Micon,
Okay.
yeah, they both say that delay in being able to do discovery or to pursue litigation goals is not irreparable harm under the factors. But to your question, Your Honor, I would point out, let's look at the motion that the state filed in this case on Friday, asking for the appointment of a special master, because there they tell you TikTok has already produced 119,000 documents to the state as part of a pre-litigation
Pause you for one
investigation.
second. Sorry, I'm interrupting you, pause you for 1 second. I presumed you all know because remember the court had granted a media request early on in this case and some of the other cases. And so what we've done on each of these hearings is that if you all have anything that you need to say that would, because there's a caveat on that media request, that if there's something that's subject to your confidentiality agreement, you need to let basically the court know, and then I need to evaluate and give everyone an opportunity to be heard. So I give that friendly reminder because I am seeing a couple new faces today or faces that haven't been here in a little bit of time. So if you were about to go into any specifics, I was giving you that pause there just so you had that friendly reminder.
I appreciate Your Honor. I probably did need the reminder, but I don't think I've crossed that line and
I
I'm not
haven't heard
planning.
anything. I would have stopped you if I started to hear something. but
Right,
that's
this
why-
was in a publicly filed motion on Friday. It's not before the court, but what my point is that the state has acknowledged we've already produced 119,000 documents already.
Okay.
So the notion of, document destruction or being lost or spoliation of some kind, I think doesn't hold water. Plus, we're, as counsel, and officers of the court, we're under professional obligations, as is our client. to preserve evidence. I mean, that we've been in active litigation for a while now. So we're preserving but hasn't already been produced, but there's already been a lot that's been produced as part of the pre-litigation investigations, Your Honor. So I don't think the arguments that you're going to hear about, we need to preserve evidence really hold water here, given what's happened both, out before this case was filed and certainly our obligations as part of this case.
Okay. And then part of a second concern weaved into that was the issue about whether or not, like, there could be a change in the status, not saying that TikTok could take actions that could negatively impact the state's case during the stay, because your state in litigation. Now, does that play a role here at all?
I'm not sure what what changes they're talking about. I'm not, so maybe I'm misunderstanding your question or their argument.
Well, the way I viewed the argument, and they'll tell me if I'm incorrect in just a moment, is that they're basically saying with the passage of time, TikTok could do certain things which could impact their case, right? That since the stay would be as to the litigation component only and doesn't have any affirmative requirements on TikTok, there could be things done by TikTok that could impact the case. And I can't give you a specific because I don't have a specific because I wasn't given one.
Yeah, Your Honor, what I understood their argument to be is that, look, every minute that this case is stayed or not being litigated, that there's harm to Nevada's youth. I mean, that's sort of the pitch, right? But what they're really saying is we're being delayed from being able to press our claims and to do discovery in our claims. And I think that falls right into the Hansen and Micon factors, which is like being delayed discovery and pursuing your litigation goals isn't irreparable harm. If they're saying something else, like we're going to change the way we operate or the way we conduct business, I'm not familiar with that argument. Maybe I can address it in rebuttal if they stand up and specify what they're talking about or what you think they're talking about, but I'm not familiar with them saying that.
I saw it as a two-prong, that it was both concepts, right? Every day harm to our community, the minors in our community, but then also new things could happen, which could basically change the procedural posture of the case, change some of the very outstanding issues, which ties into the first one or might be separate and independent. I'll stay tuned. Okay, appreciate it. Thank you so very much. Okay. Counsel for the state, who's taking this? Go ahead, please.
That would be me, Your Honor. For the states. Let's see. Your Honor, let me begin with the SNAP issue. So the critical distinction in this case versus the SNAP case is timing. So in SNAP, the move-in sought emergency relief immediately compared to here where they waited months. So that is one of the main distinctions between this case and that case. Also, under the Hansen factors, each case stands alone. We can't use another precedent to rule on this case. Each of the four Hansen factors under NRAP 8C need to be applied in order to determine whether a stay is warranted. And if I recall, Your Honor, the Nevada Supreme Court order was devoid of any type of reasoning. It simply stated that it met the four factors, not one was dispositive, and that they granted a stay. So we don't know which factor they weighed more heavily, which one they did not put value on, if any. And the circumstances here are different. Now, Your Honor, to the point where you discussed the harm to the state of Nevada, destruction potentially of evidence and spoliation, we're not saying that TikTok is intending to destroy intentionally evidence, but our understanding is this, that based on litigation across the country and since our latest meet and confer, that the defendants employ a system called LARK, L-A-R-K, I don't know what's an acronym for, but LARK is substantially different in terms of a communications platform they use internally for their corporate infrastructure than what most other companies use. I've been involved in many litigations and actually in this department, Your Honor, with my prior firm, including opioids, Route 91, City Center, all of them. And most of those litigations involved PST files, email files, collection of email files, reviewing, applying search terms, so forth and so on. And in those cases, they're complex and they take a lot of time and money. In this case, the system that defendants employ is LARK, and they've made representations to us in meet and confers that primarily the main holdup in getting to an ESI protocol, in this case, Your Honor, is that the verbiage and wording needs to be modified substantially because they don't use Outlook. or Outlook is minimal compared to what their internal Lark platform uses. And, Mr. Williams can correct me if I'm wrong, but I believe that it's more akin to Slack. It's more of a Teams type of infrastructure where you don't have email files. So we're not really sure how to handle that.
But, and let me pause you for a second, so we'll make sure we're on the same page. Is your contention that therefore they have some type of destruction policy that's going to go into force and effect during the time the writ is for documents that have not yet been produced that might be subject to being produced under like a Venetian analysis? Or are you just saying it's going to be more complex for you to get everything once can you kind of clarify, you know what I mean, a little bit more what you mean there? Because different platforms, yes, but right, if it's, I mean, remember some of the cases I get, people don't even have platforms, right? They've got all paper and storage boxes, right? And the issue becomes, yes, those still exist, paper does still exist, right? And that issue is a little bit different, right? Do they have a destruction policy that the boxes go to the incinerator, every 6 months or 30 days or whatever the case may be? So can you kind of explain how that ties into your Hansen factor? Go ahead, please.
Absolutely, Your Honor. Again, based on our understandings, it's still early on in the negotiation process with ESI protocol, but our research online indicates that with Lark, the messages can be ephemeral. They can be sent and then not destroyed, but just disappearing. And I don't know if that's a function of a setting, or I would assume that defendants have in place a strict spoliation protocol where the evidence would not be destroyed.
You're
but-
assuming they have not in the middle of litigation and they're in national litigation?
I'm sorry, putting a litigation hold on their documents, Your Honor. But the fact remains that my understanding, based on our limited understanding of the platform itself,
Mhm.
that certain messages could be sent to other teammates, and they may not be permanent, and they can be temporary. Now, whether that exists, I don't know.
Okay.
But again, that concern is there. And I know that defendants have represented that because of the Lark protocol, that the ESI protocol requires a lot of redlining. And putting 2 and 2 together, Your Honor, that gives us some concern.
Go ahead, please.
Now, I mentioned the prior cases with opioids and Route 91 and City Center. Documents take a lot of time to review, whether you do them manually with attorneys or staff, or whether you use technology assisted review or any other type of technology, right? And with 119,000 documents, that takes time. And we anticipate that the documents in this case may exceed in the millions. And if that's the case, just like in Meta, just like in Snap, and just like other social media platform litigation, that it will take time for the state to review those documents. So that is our concern, that any type of stay would slow down that process. Mr. Williams indicated that 119,000 documents have been produced,
Mhm.
but his client is also involved in litigation across the United States. They've produced documents already. Now, some might relate to that state specifically and not pertain here. We understand that. But there are going to be general liability documents, policies and procedures. We feel that those documents could easily be produced in this case at the outset.
Have they not? Is that not, I mean, maybe a while, I've been on the bench for 14 years now, but litigation, normally policies and procedures are usually the first kind of things that get produced because that's the easily ascertainable and already utilized if there's litigation in other locations. So are you saying you have a need for certain policies and procedures up front that you don't have? Or are you saying that you think that there's more out there that you're going to need and that's going to take a lot of time, or some third option?
Correct. That would be the latter, Your Honor. But it would take more time to analyze. And 119,000 documents is substantial, but again, I assume that this will exceed into the millions. And if such documents exist that are applicable to all types of litigation across the country, including Nevada, they should be disclosed now. I don't believe any documents have been disclosed since the initial disclosures have been done, or since the JCCR was submitted. So that would be another concern. Now, Your Honor, I do want to bring up a procedural issue real quick. Now, before we address the Hansen factors, I note that in defendant's reply, they raised a couple of cases that were not introduced in their motion. Typically in my experience, reply briefs are limited to rebuttal. And under the Weaver v. State case and the Francis v. Wynn case and the RJ versus the City of Henderson case, it's improper to introduce new arguments or new authorities in reply briefs because fairness, Your Honor, we don't have the opportunity to respond, and we have to take that opportunity out of time today to make those responses. So the cases that are at issue, in our opinion, are Godwin, which was from 2021, the TRP fund, which was from 2022, and the PlayUp case, which is from 2023. Now, those cases all predated years before this motion.
Mhm.
And if the defendants believe that they were relevant, then they should have been in the opening brief. But we would submit to this court that, the court should not consider them. And I know that in the reply brief, defendants cite to Ozawa to claim that we conceded irreparable harm through silence. Honestly, Your Honor, that mischaracterizes our opposition. I just want to say it might be an issue of perception versus perspective. In our perspective, this court has twice ruled that jurisdiction is proper. So we're proceeding, and defendants may not like the fact that they're litigating in a forum they don't want to be in and expending costs, but they are. So we believe that we did not abandon any arguments like Ozawa requires, but that we just come at it from a different angle. And real quick, Your Honor, the Godwin case, it's a federal case. It's not binding here, and it involves more landlord-tenant disputes, from my understanding.
Mhm.
TRP fund, it's more of an emergency stay in the context of foreclosures. Again, if it was important, I believe they should have included it in their moving papers originally. And with PlayUp, it discusses federal stay standards, and we have Tuxedo International here, which is a Nevada case, Your Honor. And we feel that that case stands for the proposition that jurisdictional objections are preserved without a stay, and that's more than sufficient. So, and to be clear, Your Honor, we're not conceding applicability of Fold in the Clark County case that was cited.
Mhm.
Those cases, I believe, were published on or around the same time briefing either concluded or after. But we recognize that those could be viewed as intervening cases. So it's fair for them to bring up, but in any event, they're distinguishable. In the Fold case, that deals with sovereign immunity and terrorism statutes regarding the Palestinian Liberation Order. And the Clark County case, I believe, dealt with qualified immunity for social workers. So with that, Your Honor, 4 factors. We believe we win in all 4 factors. Honestly, I'll go out of order. I'll jump to the last factor, likelihood of success. I think with 2 adverse rulings, it's very difficult to overcome in this court, Your Honor, to say that they would succeed on the merits. Now, we understand that there is a stay issued in SNAP. We understand that, I believe the court might have alluded to it, an answer directed in the Meta case. But those are all separate cases. As you indicated earlier, this is not Department 25.
But the other one is Department 31, right?
It
And I'll be
is.
seeing you all on Thursday on that, right?
Correct, Your Honor. But those cases, and especially the one in front of the Madison Court being answered is by, the justices, and, they might have a different take.
And that's where my question, I'd have to let you finish because that's where my question's going.
I can take your question now, Your Honor.
And please do not read tea leaves for Thursday, okay? But you all are here on different days. I put Thursdays on Thursdays to give attorneys in that case, because sorry, I set a status check on Thursday, another one of my cases I got from Meta, Instagram, and Messenger case, which you probably all know, because you probably Googled me. But surprise. But I did it so that which people are more than welcome to show up remotely. That's why I actually put it in New York, but I wanted to make sure I wasn't cutting short for anybody who possibly wanted to come in person. Okay, not required. So that's why, if you're wondering why I didn't do them both on the same day today, right? I was really trying to just be considerate to people's times on both sides, which involves some lawyers, but not all the lawyers here. Okay. But going to that case, and I'm fully appreciative it's a different case, but since both parties have argued in some version, right, snap and what the Supreme Court is doing, right, on similar type issues, are you saying the court should or should not consider that after, remember in the other case, right, Meta case is coming in on Thursday, in that there was a denial, right, initially of the writ back in January of this year. Approximately 7 months later, right, after your June, if one were to maybe do a chronology, right, after June hearings in SNAP, and I'm like I said, I'm not Department 25, but then the court had decided after a variety of different pleadings, en banc sua sponte, well, excuse me, not sua sponte, it was en banc reconsideration, right, of the entire court of a decision from 7 months earlier. So should this court be taking that into account when I'm looking at whether or not it's not a strict Hansen factor, but is it something that you're saying the court should or should not be taking into account in evaluating whether or not the Supreme Court wants to handle conceptually, don't take the fact that I'm gonna use the word similar, anything stronger than, I can't really think of a better word right now, but conceptually, some of the similar arguments being raised in different cases seems to say on a global concept that they want to do it en banc. And should I be, you're all very smart, long-standing lawyers, right? So should I be taking that into consideration and evaluating whether or not evaluating whether to issue a stay here that we all know is going to go right, depending whichever way I go. Okay, based on the law and the rules and the case law, right? I'm not saying I will be considering the other cases. I'm asking you your viewpoints, and I'm going to save it for the rebuttal because I wanted to see if it got brought up beforehand, right? Should I maybe be evaluating whether or not the Supreme Court wants to take a look at everything globally and evaluating that concept? Because remember, Hansen are factors to consider. They're not exhaustive, right? They're to consider. NRAP says it comes before this court, right? And the court's supposed to use discretion, which that gives, right? Sometimes adds extra pieces to pies and things like that. So my long question, but I was trying to give you a chance to think it through. So I was making my question rather long, although the simple concept and no one's surprised that I'm asking it. So go ahead, please.
No, thank you, Your Honor. It's impossible to ignore. I'll say that. Whether the court should factor that in, I would say no, and here's why.
Okay.
That decision to reconsider came out some time ago. If like not a long time ago, but before today's hearing, correct? So
En banc reconsideration, can you go grab it too? Ironically, they showed them the mail yesterday, the actual mail version, so I happen to have them handy. But I'd already seen them beforehand, which is why I set the status check in the other case.
my point just generally
It
is
came
that
out in the last couple of weeks. I mean, and I was gonna get the exact date, but
came in the last couple of weeks, and TikTok had the opportunity to file a notice of supplementation or some sort of, brief to the court indicating
August,
application,
I'm gonna interrupt you for one quick second, just so everyone has it clear. August 18th.
August 18th.
So it was, and I did look at, that's what I wanted to make sure. My recollection, and I'm going to double check it. Is just double checking the date of the reply. Well, it came out on the 18th, depending on how quickly people were reading their emails, if they even got notice of it, because this, remember, we don't have the same defense counsel in those cases.
Correct.
We have the same plaintiff's counsel, and I don't take any position on how quickly people scan other cases that they're not involved in, but the reply was filed on 8/19. The cases were decided on 8/18, and I believe they didn't even get posted internally to the court, I think on the 19th, whatever the date is. I set the date you saw my status check orders right after I read them.
And again, Your Honor, I will go back to my earlier point
Sure.
that it is difficult to ignore, but
Okay.
our position is that it should not be considered. And Defendants had the opportunity, I'm not taking a knock at Mr. Williams or his firm or anything, I'm just saying that they had an opportunity to file a supplement to include that into their briefing if they needed to. That was an opportunity they could have done, or address it at the initial arguments today. So, but, you know, Supreme Court in Nevada deals with very novel issues. And I know that, in their reply brief, Your Honor, defendants equate novel with the likelihood of success. So I think it's improper to conflate novelty with merit in this case, to the extent that they are. The fact that these issues are evolving and doesn't establish any likelihood of success, really. They have to show under the Hansen factors that their position is grounded in precedent and not just probable to prevail. And like I said before, this court has rejected their jurisdictional arguments twice. It's very difficult to say that under this specific Hansen factor that they would succeed. So I'll leave it at that. Moving on to, we'll just go backwards to harms to the state. We kind of mentioned that at the beginning, Your Honor, and you alluded to it. We discussed document collection, preservation. Again, we anticipate and suspect that TikTok has put in place an appropriate litigation hold to ensure that the documents are protected for this litigation. But we have some concerns given their representations of LARC being different than other platforms we've used to do e-discovery. We've heard from the multi-state litigation that there's some issues transferring the data. I'm not saying that's related to spoliation. I'm just saying that like this is new. So it is best to address now rather than put off later. And then going to the harms that we alleged, the state's complaint, Your Honor, details ongoing harms to Nevada's youth, as you had mentioned, compulsive use patterns, sleep disruptions, developmental impacts. And we included in our brief, Your Honor, some testimony that some Nevada students had given before our state legislature about fight clubs, harassment, drug sales, and violence that's coordinated through these platforms. Now, whether that is ultimately caused by TikTok's platform remains to be seen. You know, discovery will take us there. But we feel that given the harms that have been alleged, and we've met the BuzzFeed standard in this case, that it would be prudent to proceed than to issue a stay. And with regard to the irreparable harm doctrine, again, Your Honor, we cited to Micon Gaming that litigation costs don't constitute irreparable harm. Again, we don't think Ozawa applies. It's a matter of perception versus perspective. They just don't want to litigate in this forum. We understand that, but we've had 2 rulings where this court has said that jurisdiction is proper. So we believe we've addressed the issue and that the harm to them financially isn't as grave as the harms that are facing Nevada's children. And then the object of the writ, Your Honor, I'm not criticizing TikTok for participating in a case management conference. I merely put that there to lay out a timeline. I feel that had they wanted to, they could have filed a motion for stay at different times earlier in the case. And, you know, the lack of filing suggests that, you know, I actually, you know what, I can't speculate to why. But if their position has been compromised, then it's based on their own strategic decisions. And the last thing I will leave with this court is that.
You realize you're way past the
I am.
7 minutes, so.
I apologize. This will be my
Sum it up
last
in a
line.
minute if you don't mind, please.
This will be
Just
my
give
last
everyone
line.
patiently waiting. Thank you so
Yes.
much.
And look, Your Honor, this pattern doesn't demonstrate irreparable harm. It demonstrates strategic choice, as we outlined in our opposition. And after the snap stay was entered, Your Honor, clearly it was buyer's remorse. So with that, state rests.
Buyer's remorse, what do you mean by that?
They could have taken the opportunity to file a motion to stay earlier, but they continued to litigate. And that decision, they might have chosen differently.
Appreciate it. Thank you so much.
Thank you.
Okay, you know, I'm gonna ask you whether. I have to ask you the question, but I'm gonna let you address the document construction concept first.
There's a lot there, Your Honor.
Okay,
Document destruction. There's no document destruction going. First of all, talk about raising something new. Was any of this in the briefing? I mean, I'm accused of citing some cases in reply and I raised something new when this is nowhere in the papers,
In
but
fairness, the court asked some questions.
Fair
I mean,
enough.
fair enough. The medic related
problem.
question was, I asked it for a very good reason, but it
Yeah.
was a new question. And so in fairness, both sides are getting the opportunity to answer it if they want to, and they
Yes.
weren't required to answer it.
and happy to, Your Honor. We use the large system. I'm not aware of a rule that requires a defendant that gets sued by someone to use the platform to maintain emails or material in the way that the opponent wants. Our system, Your Honor, there's preservations in place.
That's really, I care about is their litigation hold.
Exactly, 100%. And whatever ways that the LARC system communicates, we're preserving those messages. The fact that the LARC system requires different language in the ESI protocol does not mean that the material isn't being preserved. It is, trust me on that. Your Honor, I guess let's start with buyer's remorse. We filed our stay motion on July 21. The Supreme Court ruled in SNAP on July 30. I don't know how we can be remorseful of something that we did before the event occurred. So let's get our timing straight. On TRP fund, let's talk about this case and the fact that it says that the court can consider the novelty of issues when determining whether to grant a stay. That does not go to success on the merits, Your Honor. What we argued it for is the factor, other proposition that can be satisfied through a showing of not success on the merits, but that there are serious legal questions involved and that you've raised a substantial question on the merits, which we clearly have done, Your Honor, and the state doesn't say a word about it. So when we cited Ozawa for like failing to engage on the issues in the brief, that's what we're talking about. Okay, so yes, you asked a very good question. Should the court consider what's going on in Meta? Absolutely, you should. Your Honor, we didn't get into that because I don't get service in the Meta case, so I didn't know that the court had granted reconsideration, so I didn't seek to supplement, or maybe I'd be accused of raising something new. But we raised SNAP, Your Honor, because the state raised SNAP in its opposition. The state tried to get out in front of it because they knew that the Supreme Court granting a stay in SNAP was bad for them. So they tried to front run it and tell you, oh, this case is different. When in reality, they had made the exact same arguments to the Supreme Court that SNAP had waited too long, that they say about us, and the court didn't buy it. This court shouldn't either, Your Honor. We cited PlayUp and Godwin, not because we raised some new legal issues, but what they say to us is some of the cases we cited didn't address stay factor. So when we talked about jurisdiction, Fulbright, Viega, that those weren't stay cases. But Your Honor, setting aside the fact that there were stays in those cases, although that's not what was being addressed in the substantive opinions, we cited PlayUp to say that courts routinely consider the fact that a motion to dismiss raises personal jurisdiction as the basis for granting a stay. Godwin says that when immunity is raised in a motion to dismiss, that too is a significant factor in granting a stay. And the Nevada Supreme Court, the Clark County case, Your Honor, that case was decided on June 12th, okay, a week after we argued in front of the Nevada Supreme Court. And what we cited Clark County for on June 21st in our motion, not in our reply, was to say, look how important the Nevada Supreme Court says immunity claims are, and that immunity claims will be lost if a party is required to engage in litigation leading up to trial, because it requires the party to participate in the very litigation that the immunity is designed to protect the party from. Now there it's talking about public official immunity, but we have argued Section 230 immunity. It's the same thing, Your Honor. We are supposed to be protected from the lawsuit at the outset. And that's why the Nevada Supreme Court has said immunity issues have to be addressed at the earliest possible time. That too is a point the state never addresses in their opposition. That's also why we cited Ozawa, because they just failed to engage on the points they know hurt it. So, Your Honor, I'm sorry to get a little exercise about it, but when I'm told I'm raising new issues in reply and I'm not allowed to cite new cases in response to positions they have taken, it bothers me a little bit. But I have nothing else, Your Honor, unless you have questions for me.
You said I should consider Meta. Why?
Your Honor, I think it goes back to TRP. The case we cited in reply for the fact that these are admittedly, they are novel and evolving issues. And that's why you didn't see me in our briefing or stand up here today and say, Judge, I can demonstrate a likelihood of success on the merits irrespective of the fact that you ruled against me twice. Okay, I know that the court did. I disagree with the court and we've taken it up. And Your Honor, we'll see what the Supreme Court does. The fact that the Supreme Court has directed now an answer in Meta, it's directed answers in SNAP. It directed an answer here. We've now fully briefed it and we argued it to the en banc courts. It's not just a 3-member panel. The point is, these issues are viewed by the Supreme Court to be serious. They're evolving. They're evolving nationwide, quite frankly. And so the fact that the court wants to weigh in on them, I think is an incredibly significant issue, whether they're saying they want to weigh in it on Meta, or they want to weigh in on it in SNAP, or if they want to weigh in it on here. The point is they want to apparently weigh in all of these cases. And so I don't think there's any ability for the court not to consider the importance of what they're doing in Carson City.
Are you saying that falls within Hansen, Micon, or TRP, which is a 2022 case, or what?
I think it, well, certainly, Your Honor, with respect to the fourth factor, okay, it's not just whether you can show a likelihood of success on the merits. The court has said alternatively, let's take Micon, good example, my case, okay, from a long time ago, unfortunately. I was opposing the stay there. And one of the things that we were arguing to the Supreme Court was, Micon hasn't shown that they're going to win on this appeal. You shouldn't grant them a stay. And what the Nevada Supreme Court said was, we don't know how the appeal is going to turn out. In other words, there had been no showing of likelihood of success on the merits. But what the court said was, you can satisfy the fourth factor a different way by showing that there are serious legal questions involved and that you've made a substantial case on the merits, not prevailing, but just a substantial case. Your Honor, I don't think anyone on either side of the courtroom here can say that we haven't satisfied that. The serious questions that are involved, the Supreme Court has told us how serious these questions are because it's directed answers in all cases. A substantial showing on the merits, Your Honor, the en banc court is considering our case. We've already had oral argument on it. I don't know if we're going to win. I don't know if we're going to lose. I don't know if it's going to be some sort of split decision. But no one can say that we haven't presented a substantial case on the merits. And that's how you can also satisfy factor 4, whether it's Hansen, Micon, or TRP.
Okay. Appreciate it. Okay. Everyone's had a full opportunity to argue what they needed to argue. So let's go to the court's ruling. So here's the court's ruling. First, let's address some of the procedural issues. With regards to some of the cases that were cited for the first time in the reply, realistically, when you look at Godwin, it's a district court of Nevada case. I can't really consider it anyway, and I don't say that it changes anything. The only case realistically that the court and Clark County 8th Judicial District Court came out on June 12th, so it's appropriate to pop it in a reply. And parties did have a chance to ask this court if they wanted us a reply. I didn't get one, so I can't take the fact that that's a new issue, and so I do have to take into account Clark County. TRP versus PHH Mortgage, appreciate that that's a 2022 case. However, that concept is not brand new to that case. It may be a case cited for that concept, but prior cases still have had that factor, and the Supreme Court and others' decisions have evaluated that concept. It may not be as clearly articulated as it is in TRP. So the court does still have to take into account the concept, because even under Hansen and Micon, the court's got to take into, like I said, those are not 4 direct requirements that are the only direct requirements, right? You have to take into account the balance of NRP 8 and looking at the generalized factors in Hansen and Micon, but there's nothing that precludes the court from taking into account other factors. So let's look at the generalized factors and where the court's going to go. The factors for the stay. The object of the writ petition will be defeated in the absence of the discussion. This is actually, I need one real quick point of clarification. The way that this motion was phrased, it was to stay all discovery. Interestingly enough, and I appreciate why it might be, because you haven't had your Rule 16, so you don't have a trial date. But was that the intention? It was discovery and other dates. And since we're at a Rule 16, which was supposed to be today, that you don't yet have a trial date, was that intentional, or you're wanting the trial date that was proposed in your JCCR to remain?
Your Honor, we were trying to be judicious and reasonable in what we were asking for, which is we know the rules. Until we have a stay, we've got to participate in the case conference. We've got to file a case conference report. We've got to serve initial disclosures. We did that. But as you know, once you file the case conference report, then discovery can commence. And so to us, it made perfect sense to file the motion at that time. And we're requesting a stay to the extent that we're not saying no one can file a motion in the case if it relates to something that someone needs relief on. I don't know what it could be, but we're not looking to shut this case down so that nothing can happen here. But what we've asked for, we think measurably, is to say no discovery until the Supreme Court rules one way or the other.
Just want that point of clarification because the way it was phrased. Okay, so with regards to the NRAP-HC factors, Hansen, Micon, and I do need to take into account the TRP concept because it really is restating what was already there. So the first factor, will the object of the writ petition be defeated in the absence of a discovery state? And the answer is yes, because realistically, as it's articulated, and I'm incorporating both the motion, the reply, and all the arguments. And by the way, I do not find that plaintiffs have waived any arguments. I don't see Ozawa applying. I don't see an affirmative waiver of anything. I really see that they've brought it and they've addressed it in different issues. So I'm looking at it as taking everything is out there, considering everything other than I mentioned a couple cases that were mentioned the first time they reply. I'm not taking into account. So when you look at that, it will be defeated because the appeal could eventually determine the void of lack of personal jurisdiction. Okay, well, discovery specifically is going to be tied into the personal jurisdiction. The 230 claim, I have to be cognizant of the fact that there are multiple aspects that are requested in the writ, and each of those, both under the 230 and personal jurisdiction, those, bless you, will be defeated in the absence of stay. So that lies in favor of TikTok. Let's go to the second factor. Defendants will suffer irreparable injury if the stay is denied. Realistically, I see this as a neutral factor because, as the case law says, with the Micon, et cetera, the fact of participating and spending the cost and expense of discovery is not irreparable harm. It's not an irreparable injury. It really is just a balance of where the resources are. So I see that's really a neutral factor that leans more towards the state. I say it's neutral, but it leans more towards the state because I don't think that TikTok has established that they will suffer irreparable injury. Now, having to participate, yes, it has some costs, whether those costs can be recovered, but under the current case law, your litigation cost is not going to meet your irreparable injury standard. Third, whether the stay will cause irreparable harm or serious injury to plaintiffs. Now, here, one of the more challenging factors, because a part of the allegations is to an impact to the minors of our community, which is a very, very serious concern. However, will the state, right? I have to look at the state. Will the state actually suffer irreparable injury or the serious harm? And I have to look at the fact of how long have these issues been going on, and will the fact that this is continued for outside of the control of the district court, because it can be totally in control of the Supreme Court, right? And there's methods to ask for expedited resolutions of writs, right? To address that issue. And I'm not saying whether you'll get it, whether you plan to do it or not. But I'm just saying it's outside the control of the district court. But when I look at the time period that's alleged in the complaint, right, and set forth in the opposition where this has been ongoing, I can't find that there's somewhat new, right? There's no new irreparable harm or serious injury. It's the same ongoing conduct which has been alleged and has been alleged for a decent amount of time. And so the court really finds that I can't determine whether or not the stay will cause the state to suffer irreparable harm or serious injury. I really see it's a very close call, but I do not find that the state has met its burden to say that, there's some new irreparable harm or serious injury, or that the continuation of what they're contending has been this serious harm and irreparable injury from members of our community, right? Minors, a very serious concern, would be really changed by a continuation versus, I did look at your JCCR and the dates you even put in for that. And when you all want a trial, it really, and since this is for discovery and does not preclude other relief potentially being sought from this court, I really see that balances the needs, and that's why I see that factor does lie in favor of TikTok and granting the stay because of those other avenues. Defendants are likely to prevail on the merits. Well, it's kind of hard to ask a court who's ruled twice one way to say that somehow I think that I'm going to be overturned, but I don't see necessarily on the merits, but then I have to take TRP. Are these serious issues that this Supreme Court is going to find that it wants to take up rather than been done by different district court judges or even one district court judge? And when I look at that factor and evaluating the various issues that were raised in the briefs, which I will reiterate, all well written, all well argued, well, I don't see what prevail in the merits. I think I have to take into account, or is there a serious issue of concern, i.e. TRP, that the Supreme Court's going to address and kind of balance it that way. I do see that while personal jurisdiction, yes, as asserted in many other cases, the 230 argument is somewhat unique and I said this previously when I ruled on the 230 argument, so it doesn't change anything I've said before, but it is unique. The court ruled the way it felt it did so appropriately, but the Supreme Court seemed to want to take this issue up. And so it is an issue that's got more broader impact. And so in consideration of the TRP case, the court really finds that lays in favor of TikTok. And when I take those all into account, the court's going to find it's going to have to issue a discovery stay only. And that's one of the things courts definitely making sure it's a discovery stay only. It doesn't preclude other relief that's outside of discovery. And I'm also going to do a status check on the stay. So I'm not going to grant it until the writ relief is completed. What I'm going to do is I'm going to reevaluate this, and I'm going to ask you all whether you think I should reevaluate it in 6 or 8 months or some other date to reevaluate this to see. I am going to reevaluate whether or not there's some harmful impact to the state that maybe has happened in the intervening time. I don't find that the issue with regards to the LARC system would have this court be precluded from issuing the stay, because hate to say it, I mean, we went from, that's why I gave my boxes of paper example, right, to the digital format, right, and ESI protocols that didn't exist. Well, back when I first started practicing law, but I'm just saying it's a realistic aspect. Having a different type of system and a different platform, I'm not seeing requires this court make a different ruling on the stay, particularly since it's been articulated to this court that there is a litigation hold. Okay. Once again, I'm not in any way saying it would be found differently, but if it were somehow found differently, of course, the court's going to reevaluate. Okay. But I've been told there's a litigation hold. I have nothing that shows me that there's not a litigation hold. I don't have anything showing me that there really is a destruction component. Okay. And so I can't say a speculative concept of a LARC system, which is a newer system that's not in a standard platform, somehow should say that should change this court's ruling. I don't find any legal support for that. And so I can't go there. So that means stay is issued 6-8 months. What do you think for a status check on the stay? And if I need to reevaluate the factors?
Your Honor, the state would request a status check sooner rather than later, so I would lean more towards 6 months or maybe even less.
No argument. 6 months is fine.
I'm going to do 6 months because realistically, since I'm doing discovery and not precluding an opportunity to file something, all right, if there's been a change, then the parties can bring it to the court's attention beforehand. And so by doing the 6-month date, I'm giving you a realistic date to actually let the Supreme Court, and I'm not in any way, I don't get to put deadlines on them. They get to choose how well they did, right? But it gives you a chance to do what needs to be done. It gives a chance to answer deadlines, right? And the various other things that can happen from a practical standpoint, but at the same time leaves the door open that if either side thinks that there's something that needs to come before this court by granting it discovery only, you have that opportunity. So I think 6 months, 6-month date, Madam Clerk.
February 24th.
February 24th, are you available? You'll make
Yes.
yourselves available? Okay,
Yes.
February 24th at 8:30. Okay, so that takes care of that. I've gone through all the factors. I did not cite every single case that was in each of your pleadings, really this court's preference. Well, my general practice is I ask you all if it's okay if I say I'm incorporating the citations to the pleadings and the various rules that were cited in your pleadings rather than articulating them one by one, just from a courtesy of the various people who are patiently waiting. And I understand the next case I'm going to take, it's got another hearing to go to as well, which will let that other judge know. But does anyone want me to go through each case and analyze each case and how it goes to each of the factors that the court went through? I'll be glad to do so if you want me to. Counsel for movement, it's your motion, so I ask.
No,
you
Your
first.
Honor.
Counsel for the state.
I don't believe that's necessary, Your Honor.
Okay.
No, Your Honor.
Okay,
Sorry.
so then we're not going to do that. That means EDCR 7.21. That means counsel for the movement, since you got granted it mostly, that means you're preparing the order, circulate it to opposing counsel, provide it back to the court in accordance with EDCR 7.21, 14 days to the DC 31 inbox. I normally would say at this time, because of the depth and breadth, that do you need more time? But what I'm trying to be cognizant of is that I'm not trying to add any dates for when this order is effective. Now, if you all are jointly asking me that you want more time to get this order in, then I'm going to grant you more time. But if one side says, no, we'd like to stick with the standard 7.21, 14 days, then I'm going to say you need to stick to the standard 14 days, because I don't want to have any unintended consequences by extending out the order that it has any impact. But like I said, if you both want it, tell me under 7.50, you both want it, you can have it. If one side says they want 14 days, I'm going to say, please, 14 days. Unless you tell me there's some good cause that if somebody's about to go into surgery, vacations, okay, something like that, that I should give you more time, let me know. But other than those factors,
Your Honor, as the party tasked with taking the initial draft, we're happy to comply with the current 14-day deadline. We'll get it to the state in enough time for it to have a reasonable opportunity to evaluate and make whatever proposals it has as well.
We're fine with that, Your Honor.
okay, and if it changes, then I'm sure I'll see a step heading my way to the order inbox. And that means, of course, the proposed order, after it's been circulated, please provide it pursuant to the administrative order to the DC 31 inbox. And I can't have you right now start telling my wonderful recorder if you want to order a transcript from today, because you can see I have a courtroom full of people. So I'm sure someone from one of your firms can reach out and do what you need to do, if that was going to be your next question.
We will, Your Honor.
Okay, anything else I can do other? Now, Rule 16 conference. I have two choices on Rule 16 conference. Since this was straight discovery, I can try and call other cases and have you do a Rule 16 conference later on. Or are you jointly requesting that I do a Rule 16 conference, reevaluate the need at the 6-month status of the stay? And then I'm going to ask you about your special master hearing. And if you all need a few moments to contemplate that out in the hall so I can call a few more cases, I'm fine with that as well. What do you all want to do?
I'm happy to give a quick response, but also to talk to the state, Your Honor, which is, I think it makes more sense to have the Rule 16 conference at or about the time of the Rule 16 conference. I would like to
Meaning
talk, or
today?
excuse me, at the time of the 6-month status check.
Oh.
I do think it probably merits a discussion in the hall as it relates to the special master motion.
Would you
Um,
prefer-
Your Honor, I would tend to agree with that, because if we set dates now and go through that process, they're not gonna hold anyway, but likely, so.
So then what we're gonna do is we're gonna continue the Rule 16 conference to see, no, I'm not saying I'm going to do it the 6-month status check, because really I'm gonna ask y'all to give me a status report, right? At least 48 hours before that 6 month, and tell me if you want to do the Rule 16 at that date, right? If there's some reason to do it, or if you're both jointly requesting that I don't do it.
That's fair.
Okay. Does that work for you?
That
work for the
works,
state?
sure.
Okay, special master, you all want to go on the hallway and discuss that for a few moments?
Correct, and one other thing, Your Honor, if I could, just for housekeeping, in light of the stay, the parties are still trying to work through an ESI protocol and a protective order. I would like to continue that process, so hopefully that's all done when discovery does actually open. So I just wanted to make sure that the stay doesn't prevent us if we need to file motion practice on those two. I'm not saying we do, because we're trying to work through it, but
It seems to me that you all might want to go in the hallway and discuss both those issues,
Okay.
right? Because then we might have a 7.50 agreement, and then this court can effectively do a couple other cases on my calendar and circle back to you when you come back. And it's going to be a perfectly fine response. Here's your other options. If you think that you need to coordinate with other people and you want to send me a joint letter, right?
Yeah.
You could do that.
I prefer that,
Or-
Your Honor.
Choice
That makes sense.
or choice 3, I'm gonna have half this group here on Thursday. If one person wants to even appear remotely from the other side, and you want me to continue that portion to Thursday, so that gives you a chance to talk, and you're more than welcome to appear remotely, then we could do option 3. So do you want in the hall and come back, write a letter, or put you on Thursday for those outstanding issues?
I would propose door number 2 for the defendant, Your Honor.
The letter?
The
Same
letter.
here, Your Honor.
Yes.
Okay,
Yeah.
then we'll just see a letter in the next couple of days, okay?
Yes.
That work for everyone?
Great.
Appreciate it. Thank you so much.
Thank
Thanks,
you.
everyone.
Thank you.
Have a great rest of your day and week until I hear from you or see you next. Thank you so much.